Thank you, Mr President.
The O'Farrell government has consistently treated psychological injuries as second-class injuries. Their pattern of removing compensation for psychological injuries is so consistent that it suggests a deeper-level ideology that sees these kinds of injuries as less real, less worthy than physical injuries. In just 2 years, this government has overseen cuts to compensation schemes across the board, including workers' compensation, victims' compensation and the police death and disability scheme. These cuts have been characterised by the removal of lump sum benefits, limiting access to weekly payments and strict time limits on medical expenses. The argument in all cases has been costs, a kind of mini austerity agenda run by the O'Farrell government, where the first thing we can't afford to look after in New South Wales is injured people. What is not being addressed in these cuts are the major cost drivers of the scheme, which include insurance industry super profits and increasingly case management costs. The most severe cuts have been made to payments for psychological injuries. In many cases, these benefits have been removed entirely. A closer analysis of the cuts to benefits for psychological injuries shows a very disturbing picture. Among the first legislative onslaughts was the Police Amendment Death and Disability Bill 2011. This bill introduced a retrospective scheme which savagely cut payments to injured police. The cuts hit injured police hard, but worst off were those who suffered a psychological injury. And this is not a small number of police. Policing in New South Wales is high-risk, high-stress environment, and approximately 80% of police hurt on duty have suffered a psychological injury alone. The majority of them were partially, not totally incapacitated by their injuries. Another 10% of injured police suffered a combination of physical and psychological injury. These changes were not accompanied by any measures to minimise the risk of psychological injuries to the New South Wales Police, or to ensure that alternative support mechanisms were available. There is real concern that these changes will mean that psychologically injured police are continuing to stay on the beat with no death and disability benefits. Indeed, many can afford to do nothing else. Not only will this likely hinder these police in their recovery, it could also place the police and members of the public at risk. The next major cuts are in the Workers' Compensation Legislation Amendment Bill 2012. This legislation was rushed through this House in just a few days, introduced on the 19th of June 2012 and passed on the 22nd of June. This hastily considered legislation ushered in savage cuts to ongoing medical benefits, weekly payments and even removed journey claims. Under the scheme, an injured worker can only make a single claim for lump sum compensation. And while various physical injuries can add up to qualify the worker as having 20 or 30% whole person impairment, psychological injuries cannot be combined with physical injuries for the purposes of calculating impairment. The result is that psychological injuries are very rarely considered, despite the serious and ongoing impact that they may, indeed often do have, on an injured worker and their ability to return to work. The bill also removed the entitlement for relatives or dependents to lodge claims for damages for nervous shock suffered as a result of the serious death or injury of their relative when their relative was a worker. This is despite the obvious fact that such an event can, and indeed many times inevitably will, have a serious and enduring impact on the life of a close family member. The basis for that cut was never made clear. That part of the scheme was not a significant cost driver. Its inclusion in the cuts appeared primarily ideological, in line with the other cuts to psychological injury compensation moved by the government. Cuts to victims' compensation were the most recent cuts that impact on those who've suffered from psychological injuries. The Orwellianly named Victims' Rights and Support Bill 2013 was passed by this House on the 30th of May 2013. It made a series of changes that will leave almost all victims of crime worse off. The legislation removed any compensation for the psychological impact of a crime in the form of pain and suffering. It then went further and shifted the focus of the compensation scheme from the actual injury that's been suffered to the type of crime that was involved. That means that regardless of the effect on an injured person, the category of crime committed was the determining and only factor for the quantity of a recognition payment. The result of this is that those who have suffered ongoing domestic violence, who are so severely traumatised that they're unable to have even a semblance of a normal life, will under this scheme compensate most times for a payment of only $1,500, if anything at all. What this means is that no matter what kind of support a victim of crime needs, or how seriously the crime has affected that victim, that it's the kind of crime as defined in the legislation that determines the recognition payment, regardless of the ongoing psychological impacts of those crimes. It's clear that as far as the O'Farrell government is concerned, whether it's victims' compensation, workers' compensation, or death and disability benefits, increasingly for this government, psychological injuries are second-class injuries. In the 21st century, this is simply not good enough.